This common judgment, my lord, there's two writ petition, my lord. I filed two writ appeal, my lord. And my lord, the another writ appeal is, my lord, this writ appeal number 39 of 2026. So in consent of the other side, my may pray this matter be fixed on 24th, my lord. I've given yesterday mentioned sleep also, my lord. 7. Page 22, my lord, this reflected, my lord, few writ petition was disposed of, my lord. Common judgment.
You want this matter to come up with some other matter?
So the common judgment, two writ petition was disposed in same order, my lord. Then another writ appeal is, my lord, it was condemned by this honorable court, my lord, and it was, my lord, this it is numbered yesterday, my lord. So that is writ appeal number 39 of 2026, my lord. So matter along with that matter, my lord, on 24th, my lord, I've taken consent of the my learned friend also.
Both says are represented on the prayer made by Mr. S. K. Mehdi, Learned CGC. List the matter on
24th, my lord. Next
24 to 2026.
Along with, my lord, writ appeal number 39 of 2026, my lord, please.
Along with WA
3926.
39 of 2026.
Highly obliged. Obliged, my lord.
May. Okay, may please. I'm paying for upgradation, my lord, in respect to item number 34, my lord. Can you take up the matter absolutely, my lord? He is Afghan national, my lord. Last more than 1 year, he is in jail.
Okay.
My lord, obliged.
May please. My lord, I am mentioning for listing of an
Listing,
I-
please give it to the court master.
on Thursday, my lord.
We are not fixing a date. Let them adjust. Thursdays we may not give.
My lord, it is pertaining to division bench 1, my lord, seeking leave, my lord,
No, division bench 1 you will make mention tomorrow because the division bench will be available from tomorrow.
tomorrow, my lord.
We are not fixing matters for the division bench 1.
There's some urgency was there,
We understand you make a mention tomorrow
tomorrow, my lord.
because we are not fixing a date for the division bench.
My lord.
May I please, Lordship. Lordship, I beg to mention item number 25 with the consent of the other party, Lordship. Matter may be adjourned for today, Lordship. Lordship, my senior is out of station, Lordship. Mr. S. Borgohain, Lordship.
Item 25.
Item 25 for hearing, Lordship. If the matter be fixed second week, any date, March of second week, Lordship.
You look his date. Both sides are represented. The prayer made by Learned Counsel for the petition will be magistrate's adjourned today. List on. Give a date, fixed date. Yes.
Humbly obliged, Lordship.
May I please, Your Lordship? Lordship, the concern of this, I beg to mention item number 24, Your Lordship. Before the appellant, Your Lordship, in this matter, Mr. P. N. Goswami, Additional Advocate General, he is appearing. He is out of station. May the matter be adjourned for today, Your Lordship. Adjournment still being circulated, Your Lordship.
Both sides are represented by circulating an advance adjournment slip for prayer for adjournment has been made by the Mr. D. Gogoi Learned, R.R. Gogoi Learned, Departmental Council. Full stop. For the magistrates, password for the day.
Obliged, Lordship.
May it please your lordship. I beg to mention item number 35 and 36 hearing list, lordship. We have informed the learned senior counsel amicus curiae, Z. Kamar and PP
That's why
RR Kaushik, lordship. I'm praying for fixing another date, lordship, due to some problem, lordship. 35 and 36 of
2018 matter, give a fixed date next week. We'll give a fixed date next week. No
Lordship.
longer adjournment.
Lordship.
on 25 to lordship.
What must we seal? Both sides are represented on the prayer made by Learned Counsel for the respondent. Miss N. Chaudhary, Learned Counsel.
yes, in that reference, and they have also recorded.
The reference case and the appellant in
36, item number
2018, the matter stands adjourned today. List on.
26.
Worship, can it on 25 to can it be on 25 to?
Twenty-five is again a motion day. This will be 26th.
Lordship.
Then we can take up the hearing.
Lordship, with the consent of the other side, I beg to mention item number 8 and 9. Kindly matter may be adjourned for that.
Lordships, I'm for the respondent in these two matters.
Lordship, I am for the petitioner in item number 9.
What say the representative?
Be safe.
There is on behalf of,
I'm behalf of K. Sharma in item number 8.
past separate ones. Item 8 and 9. And item 8, you say, both sides are represented on the prayer made by Mr. K. Sharma, and also for the petitioner, the matter stands adjourned today. On this one, this date after a week. And item 9, you say, as both sides are represented as the connected WA 349 of 2025 has been adjourned. List this matter on so and so.
Lordship, on 26th February, it's a Thursday. Actually, on Thursday, Lordship, my senior has to be in another court for High Court matters. Another date may be given. 27th. Deeply obliged, Lordship.
No, Lordship, let me mention item number 6, Lordship. Usually, as per on the instructions of the petitioners, we are not pressing the case anymore, Lordships. Yes.
Who's for elementary education department?
6.
With the orders,
You are for,
We are respondent.
I will respond to it.
and who's for elementary education department? No one.
No.
Report your presence. On instructions, Mr.
And Z Chaudhary,
N.
Z Chaudhary.
Z. Chaudhary, learned counsel appearing on behalf of Mr. A.R. Bhuya, learned counsel for the appellant, states that he has instructions not to press this writ appeal. Next fellow. Mr. P. Sharma, an additional senior government advocate for the state. Mr. R. Islam, counsel for the private respondent. Present. Matter is dismissed on withdraw. Dismiss having not been pressed.
All the Lordship.
May I please your Lordships? Lordships, I beg to mention item number 14 and 15. Lordship, the concerned lead petitioner has already died on 18/4/2024. We have received 2 copies of death certificate also.
What do you want us to do? What do you want us to do? What is your instructions? What do you want?
Lordship, dismiss the case. Lordship, may be dismiss the case.
There are
Matter has
consequences,
become partially infractious.
there are consequences attached to it.
If there is any further inquiry against any members, that law will take its own course. For the time being, I think, my lord, this matter may be closed.
Mr. M.U. Mahmood, learned counsel for the petitioner, has produced a copy of death certificate in respect of the petitioner.
Wahid Ansari.
Wahid Ansari.
In both the cases, against the one person, 2 cases have been instituted.
Disclosing his date of death as 18/4/2024. It's accordingly come up. Has submitted that. That has become the purpose. On the death of the. The court has put the learned counsel for the petitioner to notice that consequences may follow the impugn opinion. So accordingly, it is submitted that if any reference is made against any other family member, law will take its own course. Next point is that the command of the dismissed as having been rendered infructuous.
Obliged.
Death certificate made a part of the photocopy of the death certificate.
For delivery of orders, item 28, WPC 7411/25.
This petition is dismissed.
Delivery of orders, item 29, WPC 678/26.
This petition is also dismissed.
Item 30, WPC 766/26.
This petition is also dismissed.
For motion, item 1.
I for implement of the Union of India, as respondent number 8, as per direction of the Honorable Court.
Look, right, you are implementing the Union of India, but
Lordship.
get the information.
Lordship.
This. You give me a copy of the petition. It has come out in course of the last date of this, in the last date of this.
Lordship.
That the foreign, the declared foreign, name of the declared foreign national is Mohammed Mahib Ali.
Lordship. Mohibali.
And he has been declared to be a foreigner by opinion dated 22/6/2012
Lordship.
in FTG 519 of 2007.
Lordship.
And these, as per the written instructions produced by the Mr. M.R. Adhikari,
Lordship, I've seen Lordship.
he has been sent back to Bangladesh.
Lordship.
So therefore, you will be a necessary party, we are implementing you. But Mr. A.M. Ahmed, the applicant, and so for the respondents. By filing this interlocutory application, the applicant, who is the petitioner in the conducted date petition, has paid for implementing the
complete motion, statement to correct for you. Statement to correct for you.
Union of India, represented by the Ministry of Home Affairs, New Delhi, as respondent number 8. Next. Having heard the learned CGC in the matter, they are made in this interlocutory application stands allowed by allowing implement of the Union of India as respondent number 8 in the connected section. Let's go. The learned counsel for the petitioner shall provide a specially typed out cost title to the AOJ 50 section to be incorporated in the this petition. Thereupon, the petition shall be listed. Typed out copy will give it in course of the day today.
Yes, madam, I also provide that copy, my lord. In the meantime, my lord, I may be allowed to amend the cost title, my lord.
No, we are allowing it.
Yes.
We will do it by today.
Yes.
Shall provide us with typed out copy in course of the day today. To the AOJ section.
वहाँ कल दीदी मैं अपना
Process amendment being made. Central registration, the SP board of particular suitably amended. And the asset petition be listed among the nine expenses. Benefit thereafter.
We also need a copy, Lord.
Hmm?
We also need a copy, Lord. Then our name may be reflected in the book.
Okay, this is other.
This is item number 1.
Let's put the order.
Before that, or list, before that direction of listing, you want to say, and a copy of this writ petition be served on the learned CCC as well as to the learned
What's about this?
standing also for the FT and border matters. Next, the after that implement order, then you say the registry shall reflect the name of SC
FT.
SCFT and CGC in the cause list by listing the matter next.
Blush. खाली पाहिजे होतं.
Item 2 for admission.
Yes.
Your lordship, the petitioner was declared foreigner by judgment and the judgment dated 30/9/2016, my lord.
Yes.
Lord, petitioner in support of his exhibited his grandfather's voter list enrolled in the voter list of 1966, my lord. 1966 and 1970. Her grandfather's name is Shaharuddin, alias Shahiruddin, alias Shaharuddin.
Which page is that voters list?
Your lordship, page 16, my lord, of writ petition, 16.
And which page is that voters list of 1970?
1970s, my lord, page 18, 19.
1990 voters list.
1990s voter list, page 25.
This 1990 voters list contains whose name?
Petitioner's father name, my lord. Father, mother.
The only documents exhibited are exhibit 1, A, B, C, and D. Only 4 documents.
Only our petitioner has exhibited her school certificate to prove the legacy.
School certificate.
School
Exhibit
certificate.
number
school certificate, exhibit number 1, my lord.
Exhibit 1.
1. In read petition, it is made annexure 5, my lord, page 24.
Yes, Lordship, exhibit 1 and 2 was reflected in page 29. Yes.
EW2 is the brother of the petitioner, my lord. Page, in my read petition, my lord, exhibit, page number 24, annexure 5. Cabin nama, I have not annexed, my lord. Yes, my lord. Written statement is on record, my lord. Written statement is on record, my lord. I have not.
Yes, how do you link yourself with your projected parents and how, in what manner the opinion is incorrect?
My lord, exhibit, there is no finding on exhibit one, my lord. So for this, only. Further, there was also a finding that the OP has not produced any such documents to establish the proof the linkage of her father along with her grandfather Miller. 1990 voter list supports that his grandfather name is Shahabuddin, and in 1990 voter list her father name is also mentioned Miller.
Exhibit D is 1990, correct?
Yes, Miller.
What is the name of your grandfather?
Grandfather name is Shahabuddin, alias Shahiruddin, alias Shaharuddin, and alias Shahabuddin.
So the voters list is not in the name of that, any of these three names you said.
Miller.
The voters list do not contain his name. All the three names you said
Yes.
is not the voter, is not the voter in 1990.
Takir Hussain, her father name against Shahibuddin. Shahibuddin, her grandfather's name, Miller.
How do you connect yourself with this Sakir Hussain? Your projected father, how do you connect yourself with him?
The school certificate, my father's name is written as Shakir Hussain Milot.
It's okay, whatever the variations, how do you connect yourself to him?
My name was mentioned Milot, Fatima Khatun, daughter of Shakir Hussain.
Where?
The school certificate, Milot.
But the school people did not come to exhibit this document.
Except this document, no other document was reduced, exhibited Milot.
Things are not matching. We are unable to connect. You see. You, in your writ petition, you show your age to be 39 years in 2017, which makes your year of birth in 1978. Correct? 78. You get married in 1989. Your age is 11 years. And the marriage certificate does not say that you are a nabadik. So you are married off as an adult. Then there are the marriage certificate contains the name of your father. That is Muhammad Sakir Hussain. The voters list is Saharuddin. The marriage certificate was not proved by the Qazi. Whether this Qazi is authorized under the Muslim Marriage Act 1935, we don't know. 34 or 35, we don't know. It's not shown to be as the Brahmin Qazi. School certificate was not exhibited by the school authorities. Therefore, there's a disconnect when it comes to the voters list and other exhibited documents. You say that there's a change there, what there's a spelling error. Your father was alive when you gave evidence. Your father does not come to give evidence. And in the written statement, you don't introduce your mother or your brother. DW2 is your
Brother,
father.
brother.
Brother. In your written statement, you don't introduce him. But who's right? As you know your brother well, they're asking you whether what you say is, you say it honestly or your brother is more honest than you. Out of the two, petitioner and your brother, who's more honest, truthful? You can't say. You see, you come and say that your father was a voter in 1966 in Golokganj. Correct. Your brother comes and gives evidence that no, in 1966, my father resided in Tufanganj.
Where is my address?
So that's why we are asking, who is more truthful, you or your brother?
Brother has not exhibited, but submitted voter list of.
No, but his statement is there on oath. My father and paternal uncle in the year 1966 resided in Kuch Bihar, UP. WB. His name is recorded in 1966 in the electoral roll of Tufanganj number 9 constituency.
And photograph voter list was submitted in.
So that means he's a voter in two places. Sorry, we are not finding a connection. Yes, Mr. Sharma.
Lordship has already pointed out, there is no link at all. Even Lordship, his fathers and grandfather also not connected Lordship in this case. And Lordship, apart from that Lordship, from 1970 to 1990, there is a huge gap, Lordship. Continuity is not there, Lordship, which is mandatory as per section 682 of the Citizenship Act. And lordship, if we see the document lordship, a reference is made against one Fatima Bibi, wife of lordship Nazrul Haq, and lordship and petitioner here lordship projected one Sakiruddin as his projected father, but if we consider the name lordship at page 22 lordship, yes, page 22 lordship, here certified that Muhammad Sakiruddin and Muhammad Sultanuddin, son of late Sahiruddin of village Galdhua, post office Rampur, Tufanganj in the district of Coachbihar. But lordship here in voter list of 1966 shows lordship he was page 17 lordship, he was a resident of Golokganj lordship, which falls within the territory of Assam lordship. And village is Sagalia, part 2. Here village is Galdhua, post office Rampur. So all these things are not matching. Apart from that lordship, school certificate, here Fatima Khatun, daughter of Sakir Hussain. Here not mentioned that Sakir Hussain and Sakiruddin are same and one person. And here also village was mentioned as Sagalia part 2. Not a single document is connected with each other, lordship. Yeah. And none of the issuing authority has been examined in this case, lordship. Being certificate, lordship. So, lordship, I think, lordship, there is no infirmity in the opinion passed by the learned tribunal, lordship. And lordship has already pointed out the evidence part that DW2 and DW1, both the evidence are not matching, lordship. Lordship, I think, lordship, there is
Yes.
lordship, I think, lordship, there is nothing to submit more, lordship. Apparently, there is no link at all, lordship.
Send me this. It is in inside this cover page.
No.
We did not find the signature of your father here. It's available. There are two pages. This page and the next page.
No, no lordship.
Okay, we are not finding anything to sustain to sustain the challenge. But this is Royal Learned Counsel for the petitioner and so for the respondents. Argument is this the petition was filed on 18/1/2017 and pursuant to the orders passed earlier. And this could by order dated 9/2/2017 had issued notice of motion returnable in 6 weeks and record to be called for. First of all, the records has been received. However, the matter has been listed in the admission column. So accordingly, as this is an old pending matter, the matter has been heard at the admission stage. Order result. You said judgment is. Mr. Das.
Check the file, look, the first order your lordship will find.
Check it.
First order itself, my lord, all appears. And the council has filed affidavit, government has also filed affidavit. And now this case is wholly covered by division bench judgment of this court, two division bench.
Before my learned friend starts.
Yes.
We
There is
have,
not
on
starting
behalf
here
of the
right now.
chief secretary, affidavit has been filed. One affidavit of the governor, because governor plays a different role in 6 schedule areas. His role is totally different, unlike his role in other state government activities. So his affidavit, I am paying for 2 weeks time to file an affidavit on behalf of the governor.
My lord,
Make it shorter.
This-
2 weeks is too long.
my lord,
Let it be 1 week, no issues.
I'll-
I started preparing when I saw the governor's affidavit. If the case goes against him, lordship, then the question may come up before me, that why our
This is-
stand was.
I'll just, I'll help him with the two judgments of this court, which says, my
No,
lord.
it's okay, let him file because the
Yes.
governor is a party.
Had it been other case, I would not have made it, because in other cases, the governor acts on basis of the aid and advice of the state government. But here, he has his discretionary power also.
Give him time.
My lord, 1 week time, my lord, it should be hard, my lord. It's pending since last one, and it's a decided case, my lord.
No, it's
I'll
okay.
provide the copies of the
But
two
since
judgments.
the governor,
Only two judgments says, my lord, council doesn't have such power.
you file the affidavit by 24th
24th, lordship.
and 26th will fix it for consideration.
Not 26, my lord, 27th or.
Could it be on
28th?
second, lordship?
Second, yeah.
2nd of March.
Yes.
2nd of March. Second is sandwiched between 2 holidays.
Lordship. In that case, lordship, then I'll.
27th.
27 case. 27 case.
This is idea.
Yes, 27. I leave it to your lordship.
No, because
Friday, that's why I'm saying.
then Thursday, 26th is difficult.
26 is difficult. Let it be on 27, not difficult, lordship.
Because second is sandwiched between holidays.
My lord.
Sunday and the.
The bridge is coming up.
No. It's since there are 2 holidays.
I understand. Yes.
See, the difficulty is to.
No, I understand, lordship. And the Holi is there.
Sitting in the bench, it is very difficult to concentrate.
Oh, he has his, your wedding,
Yes.
his own wedding is there, lordship. So I think we should first go and attend his wedding, then come back to this case. Which-
Okay, then second point.
Second March.
Then
2nd of March.
Okay. You deserve a congratulations at least
In advance,
in advance.
and also best wishes, lordship.
Nice. Yes.
We all are going. well.
The Advocate General spoke on our behalf also.
Well, should I say about the similar is covered by judgments?
You can give it to him, we'll share it.
What do you think, Prabhu?
Heard Mr. B.D. Das, the senior counsel, assisted by Ms. Dekan and counsel for the petitioner. Someone who expresses urgency in the matter. On the ground that the matter is pending for almost a year. And the provisions of Rule 18A of the Constitution of NC Hills Autonomous Council within bracket 42nd Amendment bracket close Act 2017 is next. Mr. D. Saigal, Leonard, Advocate General, Assistant Ms. P. Barwa, Leonard. Council has submitted that in this case, the affidavit of respondent number 3 would be of vital importance, and therefore we gives leave of this court to file an affidavit of respondent number 3, for which he pays for a week's time. Please, next one. The learned senior counsel for the petitioner object to be prepared for adjournment on the ground that the matter is covered by earlier decisions of this court. Be that as it may, as respondent 3 is a constitutional authority, and the Learned Advocate General is waiting for time to provide affidavit on behalf of respondent 3 from Mr. John 3. Next will be affidavit of respondent 3 shall be filed by 24. 2026. Reply if any within 27 to 2026. This is the matter for further consideration on 2/3/2020.
Well, I also say, my lord, is covered by 2009 to
We are
GLR.
not,
Fine.
you just
Fine.
share it with Mr. Saikia.
Because it becomes easier for the court also. my lord. 2009 to to GLR.
Just write it to a slip of paper and give it.
Well.
Ask your. sitting-
I'll do it.
Highly
I'll
appreciate.
give him copy.
No, before that you say. Mr. D. Thousand and it's standing person for the NCL's Autonomous Council is present. Let's list on 2/3/2020, 2/3/2026.
Highly appreciate.
Did you have?
Item 3 for admission.
Lordship, the matter may be passed over for the time being. Mr. D. Nath, he is on legs in another court, Lordship. Okay, fine.
Just tell him the time. Tell him the time so that he can address and come.
Lordship.
Item 4 with item 5.
Matter relates to the cancellation of selection, lordship. Reading is otherwise complete, lordship. Matter can be fixed for hearing any date between the second week of March, lordship.
Yes, it depends on you because we are ready every time. If you,
Or your lordship can take up this matter.
oh, acha, this matter was heard by DP1.
Yes, lordship, for 3 point I have to clarify before that court. It would be easier for DB1 to take up this matter, lordship.
time spent is lost. The only point here was whether the tribunal was justified in cancelling the process, even after coming to know, on coming to know about the irregularities and the non-adherence to the CCTV guidelines. That is the only issue.
Lordship, that is, my lord. They have suppressed the material fact.
But that's okay, but
They have suppressed the material facts. They have not, because
no, that's okay. That you can argue before DB1 since that's the prayer.
and I have filed in my affidavit how they heavily came down the directorate against the chief postmaster general. All over India, this examination was over and result was declared. And here, without any complaint, my lord, without a single complaint, the chief postmaster general with
we
some
do it.
vested circle,
We do it without complaining the act.
without complaint, and the directorate has
We
come
have done it.
very heavily against the
We have
chief
done
postmaster
it.
general and sought an explanation as to how you, without approval of the headquarter, you have cancelled the examination.
Both sides are represented.
Dates
My lord, can it be on 10th March, my lord, if it is not inconvenient?
Notice 10th March would be too long.
10th March, because some other engagement is there.
No, because since this was parted, we can't fix a very long date. You make a prayer before the bench.
My lord, can it be, if your lordship, because no fixed date was there, therefore your lordship can fix it. I'll do on that.
No, because once it is said to be parted, because you see, otherwise what happens is that under our High Court rules, the parted tag would go. There's the difficulty.
24 or 26, 24 or 26.
Both sides are represented.
24, 26. 24, 26.
This notice that by
No,
order dated
26 January.
2026,
24.
this court had recorded that the matter was previously heard then by DB1.
No.
Accordingly, the matter stands as on today,
6 March.
based on
That's 5th March.
23rd, 24th, any day we say.
20,
My lord,
23rd, 24th, any day you say, that week.
24 maybe, lordship. 24,
26.
26.
Hearing done.
26.
27 about, no, 24.
24.
25,
25 minutes. 25 to 26. Deeply obliged. Yes. Mommy, fast separate ones.
Item 10 for admission.
My lord, here I have not received appeal, the copy of the appeal.
As actually newly entered their appearance manner after our Mozunda. I'll give that manner. Okay, this is the argument. Appeal. I Oh no, this one link, itu nalanya. Itu stay because
This A Gayan learned CGC is present for the appellant. Next, Miss
T. Wapangla.
T. Wapangla, learned counsel, enters appearance for the respondent and prays for a copy of the memo appeal. Next, a copy of the memo appeal along with the copy of the connected detail of the application is served her in course of the day.
yes.
By inclusion that day.
Hmm.
When do you want?
20 Saturday, yes, ma'am.
How much time?
2 weeks time, my lord.
2 weeks would be too long for a revision of an appeal.
1 week,
Keeping it next week,
my lord.
list from 25,
25, yes, ma'am.
2026.
Ask them.
Supplementary item 31 for admission.
No representation on behalf of the appellant. However, the Bhattacharya, the Additional Advocate General for the state is present, for the state of Mizoram is present. Speak for Prince of Justice. The magistrates have gone today. Next. List again on 25 to 2026.
Obliged.
Item 32 for admission.
Please, Your Lordship. The matter relates to, my lord, we have challenged the constitutional validity of Rule 14 of the Secondary Education Provincialized Rules 2018, my lord. My lord, in this matter, my lord, I am led by Mr. K. M. Chaudhary, my lord. He is on legs, my lord, in a part-heard matter. May I pray that a matter may be taken up on next Monday, my lord.
This one is not there.
Yes.
Mr. R.M. Dekar, learned counsel for the additional. Submits that the place for adjournment, there is allowed. List again on
23rd, my lord.
23,
Right.
2026.
And deeply obliged, Lordship.
No representation of the respondents.
Deeply obliged, Lordship.
I'm the parents for the respondents, you will be first. After that, the this one.
Item 33 for admission.
This item may be possible to the family.
Kindly. Just tell him that time. Yes, Mr. Council. Tell him time, tell him the time, he will be busy in other courts. Tell him how much, after how much time.
Time. After 10-15 minutes.
For admission, supplementary item 34.
May it please, Your Lordship. My last order, 28/1/26. And this is the instruction I have received, Lordship. I'm gonna get a copy. Good afternoon. My. Lordship. Lordship, there, it will take time because it is in the Ministry of Home Affairs, Lordship. Next. Lordship. Right? Let it be after 2 weeks, Lordship. And my lord, the trial court will proceed without me, my lord. I am not unable to file my written statement. I have been transferred here only because. Then next week, Lordship, I will try, Lordship.
Would adjourn the proceedings in his, on his prayer.
Lordship.
Otherwise, he'll be prejudiced if he's not filing a written statement.
Lordship.
He'll allow an adjournment. See, take it. The matter is pending before which tribunal? It is before which tribunal?
My lord, Nalbari, Finance Tribunal, Nalbari, FT case number N 5625.
Just give it the number.
My lord, I will write it and give it, my lord.
Because there are several tribunals in Nalbari.
My lord.
Lordship, one more thing, Ministry of External Affairs may be made party, otherwise Lordship to bring the records from External Affairs, Lordship, it is
Difficult.
Lordship.
There are several tribunals in Nalbari.
My lord,
which-
I'm placing that. That's what I'm saying.
Mr. P.K. Roy Chaudhary, learned counsel for the petitioner, who is present and expresses urgency in the matter. To his apprehension that while the petitioner is in custody, the foreigners tribunals so and so leave a gap. They proceed with the trial of case number so and so gap. Next, paragraph. Mr. S.S. Roy, learned CGC, appearing for the respondent number 1, has submitted that pursuant to order dated 28/1/2026, he has received written instructions from the regional passport officer.
Sure.
That comma stating
Stating-
stating
Steno-
inter alia, comma that
Stenographer of the news.
the
Protocol.
Ministry of External Affairs by email dated 2/2/2026 has conveyed that the fingerprints which were sent by capital CCB-1, Chennai in capital CBEFF format have been matched with the biometrics connected to passport number capital V1736451 of Mohammed Mohammed Dilowar Dilowar Network Khan. Next paragraph. The learned CGC has submitted that is finding some difficulty in communicating with the Ministry of External Affairs as they are not party respondents. And therefore he submits that he has to route his communications through. Just stop there. Next paragraph. Having regard to the fact that the allegations against the petitioner is that despite holding a passport of India, he also has he is also accused to have a passport issued by the Islamic Republic of Afghanistan. Therefore, the court is of the considered opinion that the Ministry of External Affairs would also be a necessary party. So accordingly, the court is inclined to implead the Union of India represented by the Ministry of
External Affairs. Represented by the Secretary to the.
By the Secretary to the Government of India, Ministry of External Affairs, New Delhi, as respondent number 7. So the registry shall carry out the necessary correction and shall also update the CIS system. Next one. The learned CC has submitted that has wait for at least 2 weeks time to get the necessary documents and obligor instructions. Next one, considering the fact that the petitioner is in custody since you are in custody since
My lord.
he was in custody for considerable time.
18 from.
You said considerable time.
18/12/25, my bail application was moved. 18/12/25.
We don't give that date, we say considerable time,
No.
because then there'll be difficulties. We grant 10 days time to the competent authority of the respondent, number 1 and 8, and number 1, and newly imputed respondent number 7 to provide sufficient instructions to the learned CCC for being produced before the court. Next paragraph. In view of the apprehension expressed by the learned counsel for the petitioner that in the meantime, the foreigners tribunal Nalbari-1 may proceed with the trial of FT within bracket NAL bracket close case number within bracket capital N bracket close 56 of 2025. In the absence of the petitioner who is under detention, the court is inclined to provide that on the prayer for adjournment made on behalf of the petitioner, namely Mohammad Dilawar Khan, said learned tribunal shall adjourn the matter till 5/3/2026.
Six, three, huh?
Next para. List the matter again on 26/2/2026. Next para, so that where we stopped at this, you got 10 days time. You had, in this regard, the learned CGC is requested to send a download copy of this order to the competent respondent authorities to obtain instructions. After that, the other part. See list on sales.
Yeah, not sure.
So before that, you say that the copy of instructions dated 3/2/2026, as produced by the learned CGC, is written on the.
Sincere apology, Lordship. We missed the item number 31. My name may be record, Lordship.
Item number
31, Lordship.
31.
Lordship.
In that item 31, you say later on, Miss
And Kakoti, Lordship.
and Kakoti, learned counsel enters appearance on behalf of the appellant.
Highly obliged, Lordship.
তুমি পিছনৰ কপিটো পেক বনাই লিখি আনিব লাগে একবাৰ ৰাতিপুৱা নাম্বাৰটো দি দিম তুমি চাই দিবা চিঠি নম্বৰ
Meditation.
Mr. Pathak, how is the senior Mr. Pathak? Stable?
Stable.
Yes.
Lordship, we are against the judgment passed by the learned single judge below your lordship in a petition, whereby we have challenged inspection report, a Caesar list, and assessment bill. And also the disconnection made by the responding authority on the allegation of theft, your lordship.
Why would this be entertained in a writ petition when you have alternative remedy?
That is our case. We don't have any alternative remedy under section
Why?
135. Under 135, we don't have any alternative remedy, your lordship. Your lordship may kindly come to the interim provisional bill, your lordship.
Your Electricity Act.
The Electricity Act. The relevant provisions I've compiled, your lordship. Be convenient if your lordship takes up the relevant facts that I.
Yes, sir.
Just act or section compile. In my compilation, your lordship, at page 14, section 135 is. This is not under dispute that the bill has been raised, not raised under section 135.
Page number
Page number 14 of my compilation. Your Lordship.
14.
14, 1-4. If I may read, your lordship, 135, 1. Down below, your lordship.
Yes.
Whoever dishonestly A, taps, makes or causes to be made any connection with overhead, underground or underwater lines or cables, or service-wise or service facilities of a license or supplier, as the case may be, or B, tempers a meter. This is our case, your lordship. Installs or uses a tempered meter, current reversing transformer, loop connection, or any other device or method which interferes with accurate or proper registration, calibration, or metering of electric current, or otherwise results in a manner whereby electricity is stolen or wasted. This has to be there, your lordship. And then number C, D, E, and finally, after E, your lordship, so as to abstract or consume or use electricity. So the tempering must lead to stolen or wastage of electricity, so as to abstract or consume or use electricity will be punishable, your lordship. Now, your lordship, the first provision, provided that in a case where the load abstracted, consumed or used, or abstracted or attempted consumption or attempted use does not exceed 10 kilowatt, then the punishment is given.
Put your papers down. It's
Oh. The kilowatt, if the stolen, this has to be quantifiable, your lordship. If the stolen electricity is 10 kilowatt, above 10 kilowatt, then the punishment is different. And below, sorry, one is below, and if it exceeds 10 kilowatt, then the punishment is different. So this is a punishable offense, and as your lordship has seen, the section starts with the word whoever dishonestly. So mens rea is a very important ingredient here, your lordship, and this is a punishable offense. Now, your lordship, if your lordship may kindly skip second and third proviso, sorry, and come to 1A. 1A, your lordship. Without prejudice to the provision of this act, the licensee or supplier, as the case may be, upon detection of such theft or electricity, immediately disconnect the supply of electricity. Hereby, they are authorized to disconnect the electricity supply, your lordship. And here the third proviso, provided also that the licensee or supplier, as the case may be, on deposit or payment of the assessed amount or electricity charges in accordance with the provision of this act, shall, without prejudice to the obligation to lodge the complaint as referred to in the second proviso of this clause, restore the supply line of electricity within 48 hours. So a particular amount has to be assessed after disconnection, and once the consumer pays that amount, it will be, the electricity supply will be restored. So this is what, and one important ingredient is that they will have to lodge a FIR within 24 hours before the police station having jurisdiction. I'll come to that, your lordship. They have not done it. And your lordship, now, since this is a penal provision, your lordship, what about the civil liability or the damages that has been caused, that could have been caused to the respondent authority? That is taken care of by section 154(5), which is at page 19 of my compilation, your lordship.
page number.
Page 19, section 154. This is the procedure and power of special code, your lordship. A designated special court was established under this statute. Notwithstanding anything contained in the Code of Criminal Procedure, every offence punishable under Section 135 to 140 and Section 150 shall be triable only by the special court within whose jurisdiction such offence has been committed. This takes care of the penal provisions, Your Lordship. And finally, at subsection 5 of 154, the special court shall determine the civil liability against the consumer or a person in terms of money or theft of energy, which shall not be less than amount so and so. So, Your Lordship, the civil liability will also be determined in case of theft by the special court. The assessing officer is not authorized to do so, Your Lordship. And at the third proviso of Section 135(1)(a) that I have just shown, Your Lordship, it takes care of the interim measure only. It's an interim measure only for restoration of electricity. Now, the amount to be assessed, if Your Lordship may kindly come back to Section 135 once again, Your Lordship, 1A.
Page 50. Page 50.
Yes.
135, 1A, the third proviso, I'm reading again, Your Lordship. At page 15. Provided also, after the electricity is disconnected, Your Lordship, provided also that the licensee or supplier, as the case may be, on deposit or payment of the assessed amount of electricity, in accordance with the provision of this Act, shall without prejudice and so, restore the electricity connection, Your Lordship. So, in this particular Act, Your Lordship, there is no provision for assessment of electricity under Section 135, 1(8), the third proviso, Your Lordship. The only relevant section here is Section 50, Your Lordship, which is at page 10.
You see, if according to you, the provisions provide for determination of civil liability and the criminal liability by a special court,
Lordship.
what remains for the writ court to interfere in such cases?
In our case is that this is not a case under Section 135. At most, it can be a case under Section 138, and under 138, there is no provision for disconnection of electricity. This is our case, Your Lordship.
According to the report, you have been found with tampering of the meter.
But not that I can show from the facts of the case, Your Lordship. Tampering of meter is different, Your Lordship. Your Lordship, you kindly come to 138. That will clarify, Your Lordship. Section 138.
Which shows the facts first, then we come to the law.
Lordship.
Shows the facts first. Then we
Yes,
come to
yes,
the-
yes, definitely, Your Lordship. Your Lordship, may kindly come to page 106 first.
Because reading act in what you call
Without the facts, yes.
without the facts.
Yes.
It's reading something.
Yes, Your Lordship.
In vague. You are in this writ petition challenging the validity of the inspection and seizure report.
Lordship, and the subsequent assessment also.
A subsequent assessment. Now,
The amount assessed, as I
Where
have
is-
shown, Your
where is the-
Lordship,
where
is
is the-
an
where is the-
interim measure only for restoration of electric supply, Your Lordship. Your Lordship, may kindly come to page 106. Facts starts here, Your Lordship.
you see, we are asking you these questions, come to page 112. That is the reason for asking you that.
Lordship. Yes,
This was the
observation made by the repainting of our
Observation.
company.
here, first thing you say is case, actually false case is made.
Yes, Your Lordship.
All seals made in so and so were cut, broken and tampered by the inspecting team
Yes,
famous.
yes.
These are all questions of fact.
Lordship, they have also violated all the provisions during the inspection, your lordship.
You see, they have no animosity with you. Nobody would come into the, you see, I myself have been a consumer, electricity consumer for so long. Nobody entered in my house at any point of time since the days of my parents and me. To just open the gate, tamper the meter, and then accuse me of the theft. Never happened.
It never happens in our houses, your lordship, but in factory, the amounts are also on the higher side. And but anyway, your lordship, even if this is not to be, since we don't have any evidence, this is only our, even the entire inspection was carried out without following the provisions of law. This is our case, your lordship. And there, whatever they have stated, your lordship may kindly come to the inspection report first, your lordship. And before that, if your lordship may kindly come to 106. I'll just put the
106.
facts with you briefly in 5 minutes, your lordship.
106.
106. This is the first inspection that took place in the year 2018, your lordship. I'll just show one paragraph from each inspection report, then it will clarify you. At page 106.
Satisfactory.
Yes, your lordship. Checked and found satisfactory. And then your lordship may also come to page 108. 108 is the abstract of the meter record book that I have furnished, your lordship. And at page 109, your lordship. 109, your lordship. The first column, date. 109.
Yes.
The date column, your lordship. The third 1/3/2019. Lordship got the date, your lordship.
Yes.
In the March of 2019, and on the 1, 2, 3, 4, the fourth column, that is sealing done with signature. They have sealed it, put their signature, and CMRI has been taken, your lordship. This is important, your lordship. This is common meter reading in instrument, your lordship. And then next page, your lordship, page 110.
Yes.
Date here is 8/4/2019. Here also they have done the meter sealing and everything. No anomaly were found, your lordship. And CMRI was taken. The data were downloaded from the meter, your lordship. And just after 2 days, exactly on the third day, your lordship, on 11/4/2019, they came again. And this is the inspection report which I have challenged, your lordship, at page 111.
Not connected with this case, I'm just sharing some information to you.
Lordship.
Are you aware of the fact that when you travel by any road,
Lordship.
at some distances everywhere, you will find out of nowhere in a that light post,
Lordship.
meter is installed
Lordship.
by the APDCL. We have seen that, noticed it, no?
Yes, yes, I have noticed, your lordship.
Can you tell us, have you ever thought why this meters at locations where there is no consumer is put up?
Wow, I'm not aware, your lordship.
You're not aware. This is to assess theft. Because if in the locality in one place,
Oh, but
in one place there is a there are 10 consumers. I'll give you an example. And in the outside the road there is a meter. The average electricity consumed in this 10 household is say 1 kilowatt.
oh, it will tell you
And,
this.
and that shows 2 kilowatt. That means there is a theft of 1 kilowatt.
Okay, okay, lordship.
So therefore, owner of the establishment, that is the APDCL, going to their what you call selling point, that is the consumer, to see and inspect even after 2 days will not be wrong.
Lordship. I'm not on that also, your lordship. What I'm trying to infer from here is the period is very essential for assessment, your lordship. For the purpose of computation and assessment of the loss, or for the assessment of.
That the read code will not do. If you want me to do an arithmetic, this will take me a year.
No, I'm just showing. Apparently, what I can show, apparently, your lordship. This, if your lordship now come to the general marks on observation at page 111, your lordship. As per instruction of the GM, metering installation is checked and found meter terminal cover seals bearing so and so are found in tempered condition. Meter cover and terminal cover seal bearing so and so is found in broken condition. CTPT secondary terminal cover seals are found in tempered condition. These are the allegations, Your Lordship. And on the basis of these allegations, they have arrived the second sentence, as per section 135 of the Electricity Act, the power to the consumer is disconnected. Only on the basis of this allegation. Now, your Lordship may kindly permit me to take to the photographs that I have annexed, Your Lordship. I'll not bother much about the facts of the case. This is the last thing I'm showing, Your Lordship. I'm aware, Your Lordship, this is the report, Your Lordship. I'm just showing at page 142. I have annexed the photographs, Your Lordship.
Yes.
Now, this photograph at figure 4 at page 142, Your Lordship. This is the metal cabinet box with seal, Your Lordship. Now, I have shown the paper seal and the white seal. Without breaking this seal, it is impossible to tamper the meter, Your Lordship. Thus, theft of electricity without breaking the cabinet box, it is not possible, number one. And then at page 144, this is the meter, Your Lordship. Here, one thing is crucial, Your Lordship. At page 144,
Even if only assessment under 130. So there, demanding 50 there, legal. Because it was. On trees whether invitation happening and whether filing objection of the big proposal making. Yeah, what to look on our petition was on set.
Yes.
Your lordship may kindly come to page 160, page 1616 of the compilation that I have given your lordship. This is section 135. Your lordship have already gone through the allegations in the inspection report. Your lordship may kindly come to section 138 now, which is at page 16 of my compilation, your lordship. One 138, interference with meters or works of licensee. 1. Whoever A, unauthorizedly connects any meter, indicator or apparatus with any electric line through which electricity is supplied by a licensee or disconnects the same from any such electric line, or unauthorizedly reconnects any meter, indicator or apparatus with any electric line or other works being the property of a licensee when the said electric line or other works has or have been cut or disconnected, or C, lays or causes to be laid or connects up any works for the purpose of communicating with any other works belonging to a licensee, or D, this is important, your lordship, maliciously injures any meter, indicator or apparatus belonging to a licensee or willfully or fraudulently alters the index of any such meter, indicator or apparatus, or prevents any such meter, indicator or apparatus from duly registered, shall be punishable with imprisonment for a term which may extend to 3 years. Section 138 doesn't speak of any assessment or disconnection, your lordship. 138 is also punishable by the same procedure, your lordship, that I have shown under 154 special code, your lordship. At best, your lordship, even if the allegations are taken as gospel truth, then also only section 138 will be attracted. 135 cannot be attracted. So our first line of argument is that any assessment bill or the inspection report or the seizure done under 135 is without jurisdiction, your lordship. They have wrongly exercised the jurisdiction, the assessing officer. Your Lordship.
But the cause of action for a prosecution has not arisen. Before that, how can we say that the prosecution would not lie?
Because under 135, I have already shown, your lordship. Again, your lordship may kindly come to section
You have
135.
not been, your own statement is that you have not been prosecuted till date.
Lordship, to prima facie establish theft, certain ingredients under section 135, also under AERC regulation, has to be satisfied, your lordship. Your lordship, they have not shown, even if there is tampering, your lordship, how that tampering has resulted in wastage of.
My example may be very horrible, but still it's an example. Now you see, the person has been charged of taking a bribe. He has been not read taking bribe. Now, can somebody come to the court and say that this offense is this and this is ingredients are there, offense is not made out? Please quash the initiation of the proceedings.
Only if the ingredients of that particular section is not
But
attracted.
it has not been prosecuted yet. No charge sheet has been filed. No FIR has been in the FIR has not been presented with a charge sheet.
Even they have not, one of the condition is that they have to lodge a FIR before the appropriate authority having jurisdiction. That also has not been done in this case, your lordship.
Then can we give an opinion
And
that it's not prosecution is wrong?
My case is that if the ingredients, if the provisions under section 135 as well as 1A are not satisfied, then they cannot disconnect my electricity, your lordship. They are exercising their jurisdiction. They have exercised their jurisdiction, your lordship, even when they don't have any, your lordship. That is my case, your lordship. First. And secondly, as I have shown, your lordship, I can show it again. Under 135, there is no provision of appeal. The special code will come into play only after the search is filed, as your lordship has rightly pointed out, your lordship. Only when conviction is done, then only civil liability come. This is the interim measure, your lordship. Only for the purpose of restoration, they have to make an assessment. That also they have done all by violating all the provisions of law. One by one, I can show your lordship. I can satisfy your lordship that they have not followed a single provision of law. That is why 135 is not attractive, your lordship. If your lordship permits me, then I can show your lordship all the regulations and the section. Your lordship may come again to section 135. That will itself clarify, your lordship. Section 135, your lordship. I am reading the relevant portion again, your lordship. 135(1). Whoever dishonestly Here, there is no allegation of manslaughter, your lordship. There is no allegation that I have done anything dishonestly. And there is also other provision, your lordship, under 126, your lordship. I'm not coming to that, your lordship. For tampering, this is not, for tampering, this has to be done dishonestly, your lordship. That is why section 135. Section 126 of the statute takes care of tampering without dishonesty, your lordship. Here, there is no allegation that I have done anything dishonestly, your lordship. And then, your lordship, B, whoever dishonestly tampers a meter, install so and so, which interferes with accurate or proper registration. There is no allegation that there is some inaccuracy in the registration of electricity bill, your lordship. And then also calibration or metering of electric current or otherwise results in a manner whereby electricity is stolen. They will have to show, your lordship, in the inspection report or the seizure list or in the assessment bill anywhere, your lordship, that in the inspection report particularly, that the tampering has resulted in a manner whereby the electricity has been stolen. This is not their case, your lordship. They have not shown anything that the tampering of meter has led, and I've shown, your lordship, in the photograph without breaking the cabinet seal. How can somehow someone temper the meter in such a manner that the electricity can be stolen, your lordship? They have not seized, and they have violated the seizure procedure also. Their allegation is that the seals were broken, but they have not seized the seals. In the seizure list, they have not seized the seals, your lordship.
So they were broken by themselves.
That's why my allegation is substantiated that they have broken it themselves. And that is why they have not taken it, your lordship. But I'm not going to that, your lordship. So these are the basic ingredients. Without this, how can section 135 be attracted? That is why I'm before your lordship. There is no provision of appeal, and the special court will come into play only after the circuit is submitted, your lordship. And this is also not a case of civil liability, as they are repeatedly trying to put it up, your lordship. Civil liability is different, your lordship. Definitely, I understand. If I have stolen something, then I'm also liable for the civil liability, your lordship. That again will be taken care of by the special court, not by the assessing officer, your lordship. Only assessment that is permissible is under 135(1)(a) third proviso, your lordship. That is an interim measure for restoration of electricity. Nothing to do with civil liability, your lordship. Nothing to do with the damage that I have caused, your lordship. Even if it is taken that, even if it is assumed that I have stolen something, your lordship. There is no allegation that I have stolen anything, your lordship. Only tampering, mere tampering allegation is there, and they have disconnected, and they have raised that assessment bill of 11 kitna crore ka hai? Of 11 odd crore, your lordship.
And now they are relegating us to appellate authority.
So my two primary thing, one is that they have done it without jurisdiction, number one. Secondly, there is no provision for appeal, your lordship. And I am against the judgment of the learned single judge because learned single judge held that as a natural corollary of something, your lordship, appeal will lie. And your lordship, no, appeal it has to be given by the statute itself. If there is no statutory provision for appeal, I cannot file any appeal anywhere, your lordship. Appeal cannot be a natural corollary, your lordship, of another provision, your lordship. This is not right to sue, your lordship. Your lordship, everything will be clear if your lordship kindly come to section 50 also at page 10, your lordship. Why I am saying repeatedly that there is no appeal. And why this assessment under third proviso of 135A?
156 of the Act says the appeal and revision both. 156 of the Act refers to appeal and revision. And again, the power of review has been vested under 157.
156. 156. This is against special code, your lordship.
So special court will first determine.
Yes, your lordship. Again, I'm repeating your.
Order of the out of the statute, the APDCL officers, there is no appeal lies.
Why this is confusing, your lordship, then may kindly come to section 126. They are trying to put it as if this is a case under 126. Section 126 speaks, your lordship. I'm just putting it, speaks that if there is any tampering of meter,
You see,
then
that's why we are asking you, what is the communication of offense given to you?
it's under 135 theft.
First that.
The first, your lordship, at 111, the inspection report I have shown as per section 135, disconnection is made, and then specifically in the inspection report itself, your lordship, sorry, the assessment bill. Assessment bill is At page 121, your lordship. This is the provisional assessment bill they have raised, which they cannot, your lordship. This at 121, format 17, assessment bill. Within bracket, serving assessment bill, consumers disconnected under section 135. So this bill has been raised under 135.
I can speak more. Really?
You're reading which page?
Page 121.
121.
Yes, your lordship. Of the writ appeal, your lordship. No, this they have not denied that this is a case under 135. Assessment bill under section 135 of Electricity Act. In the statute, your lordship, there are two provisions. One under section 126, which is exclusively civil in nature, your lordship, and 135, which is penal in nature, your lordship.
Against 126.
Against 126, appeal lies under section 127. And the confusion here is that they are also dragging the offenses under 135, under section 126, and then the learned single judge said that since this is an assessment made under 126, as a natural corollary, appeal will lie. We are against that particular direction of the learned single judge, your lordship. Your lordship may come to page 126, your lordship section. Kitna page number?
No, because we are confused because of the fact that there's no provision here which says that the orders passed by the special court would be final.
Yes, your
And
lordship.
no appeal would lie.
Yes,
That-
we are
that
much
prescription
earlier
not
to
there.
that stage, your lordship. That phase will come
No,
later,
no,
your
that
lordship.
prescription is not here,
No,
that the orders of the special court would be final.
no, the appeal will
why-
lie after special court order, definitely, your lordship.
So why as a natural corollary, you don't have a provision for an appeal or revision?
Under 135, there is no, that is why your lordship may kindly come to 126 now. Everything will be clear, your lordship. Section 126, your lordship. Compilation, page 11, your lordship. I've shown 135, now 126, your lordship. This is where appeal lies. I'll come to 126 and 127, your lordship.
No. You see this, the provision of 126 is contained under part 13.
Yes, part 12.
Part 13 contains, I think 13.
12 in part 12.
12.
Yes, investigation.
So 12 is a
Investigation.
complete- 12 is a complete code so far as the appeal is concerned.
Yes, your
Offense and the appeal.
Yes, your lordship.
Then this 135 is under chapter, is under part 14.
Yes, your lordship.
Here, the offenses is made. And then in this part only, you will find this. You find the procedure of still compounding.
Yes,
Then-
your lordship.
Then special courts is part 14
Yes.
and appeal provision is contained in that part only at 156.
After special court judgment, your lordship. Yes, your lordship. Here, 126, under 126, your right, lordship, you rightly said that this is this is a complete code, your lordship. Part 12. So here, if the assessment is made under 126, then I have a right to file an appeal under 127. That much is understood. But the learned single judge below has said, directed us to file an appeal under 127, even though assessment was not made under 126, but it was made under section 135. This is our case, your lordship. This is our case, your lordship.
Okay.
We cannot file an appeal under 127, your lordship. Your lordship has rightly said that this is a complete code, your lordship, which takes part of the civil case, your lordship, civil code, your lordship, civil liability. उसमें अभी मत जाओ उसमें बोल देना it's a different thing हो गया
Put your question.
Lordship.
My examples are always horrible, you excuse me for that. Now you see, against orders passed in the civil suit,
Lordship.
I'm comparing it because
Lordship.
somewhat parameter to my example.
Yes, Your Honor.
Now, in respect of many orders, it is said that you can challenge those interlocutory orders at the time of filing of an appeal,
Lordship,
correct? 104 or 105 CTC.
order 41.
It doesn't cover under order 41. And there are certain provisions which can, for which an appeal is permissible under order 43 rule 1R.
Yes,
or
Your-
one, order
yes.
43 rule 1.
Yes, Your Honor.
So can someone come and say that I don't have a statutory remedy and therefore against this order, I come to the High Court in a writ petition? No. All orders are neither revision, there cannot be a revision against all orders passed by the civil court because of the fact that what you call the appellate provision is not there and the judicial review against orders passed by on interlocutory orders is not permissible.
True, Your Honor.
Therefore, how does this idea occur that if an assessment bill is given under 135, then an appeal provision would be under 126?
This,
And it can also be the legislative intent that for certain offences, you, at an interlocutory stage, you don't have a right to appeal.
yes. Yes, so we
Then
didn't
you
approach,
lose that-
yes, yes, true, Your Lordship. We didn't approach the learned single judge below saying that we have come because there is no right to appeal. We approached saying that there is no jurisdiction. Without jurisdiction, the assessing officer has disconnected the electricity supplies. That was our case, Your Lordship. That was our case. We never said that we have come only because there is no provision of appeal. We never approached the jurisdiction for that, Your Lordship. Your Lordship have rightly said, very fine example, Your Lordship. We have never approached this honorable court, the learned single judge below, saying that we have come because there is no provision for appeal. No. We have challenged it on the ground that they don't have any jurisdiction to do so, Your Lordship. I'm before Your Lordship, before Your Lordships today, because the learned single judge is wrongly held that since there is a provision for appeal.
Mr. Kamal has come for the argument in lunchtime.
Date reference
Oh,
case, my
correct,
lord.
correct.
Actually, paper book is not ready. It's going to come from. In that case, paper book probably has been made ready. It's only yet to be distributed to us, my lord.
So, which is that
Paper
item,
book.
item number?
So that can be disposed of.
12 and 13.
Yeah.
Item number?
12 and 13.
12 and 13, my lord.
Yes.
Oh, very good.
Nine.
I thought, looking at you, I thought that we would skip our lunch and then.
My lord. So we'll also get freedom, my lord. So only thing is that the paper book, if ready, should be served on us, my lord. That much so much.
Without record, I would not.
Oh, no, definitely, my lord. We have checked it, that's why we said, your lordship will have a look. Miss Aisla.
Post away by probably comment. PB5 numbers.
Appellant said in apple.
Paper book ready also.
Situ bomba, everything is subordinate in power. Allow one will
सुबह सीनियर को नहीं है पेपर पेपर बुक रेडी আছে তোমাদেরকে পাইছা আমি পোৱা নাই
I think it has been distributed. I think some parts of it has been distributed. Yes.
and PP officers also
We have
received it.
received an
Uh,
informal.
Ms. Bhuya has been
Yes,
provided with a
And
copy.
they have got, Mr.
Volume
Gogoi
1
has
and 2. Yes. Yes, 5-6. 5-6. Second. We'll just direct the
Well,
copies to be given to you. That's
Sure,
all.
man.
Okay.
To
Lordship.
me as an amicus curie and they as the
I'm for appellant.
Appellant.
We also haven't received the copy, Your.
So, 1 and 2. 1 and 2 will be given to you. That's all. Okay.
Lordship.
Lordship. 1 and 2 will be given to you. That's all. Okay. 1 and 2 will be given to you. That's all. Okay. 1 and 2 will be given to you. That's all. Okay. 1 and 2 will be given to you. That's all. Okay. 1 and 2 will be given to you. That's all. Okay. 1 and 2 will be given to you. That's all. Okay. 1 and 2 will be given to you. That's all. Okay. 1 and 2 will be given to you. That's all. Okay. 1 and 2 will be given to you. That's all. Okay. 1 and 2 will be given to you. That's all. Okay. 1 and 2 will be given to you. That's all. Okay. 1 and 2 will be given to you. That's all. Okay. 1 and 2 will be given to you. That's all. Okay. 1 and 2 will be given to you. That's all. Okay. 1 and 2 will be given to you. That's all. Okay. 1 and 2 will be given to you. That's all. Okay. So we have the count.
Sure, much.
Two copies with us.
Oh,
Third
yes.
Copy, fourth copy, fifth copy. is there.
Yes, sure, much. Only direction may be given to serve the copy.
This item number was 12 and 13. You have separate orders, huh? In item 12.
Appeal to.
In item 12, who is for the petitioner?
We are.
Appellant.
For the appellant, yes.
Yes.
Your name?
P. Khatun, Your Lordship.
Representing Borthakur, my lord.
On behalf of Council S.
No,
Borthakur.
his name is recorded here.
Yeah.
So, but Mr. P. Khatuniya, learned counsel for the appellant. And Ms. B. Bhuya, learned senior counsel, and APP for the state, assisted by Ms.
R. Saloy.
R.
Saloy.
Saloy, learned counsel. The officer reveals that the paperwork is ready and a copy has been served to the learned public prosecutor. Let let a copy of the paperwork be served on Mr. Z. Kamar, learned Michael Curie, appearing in death sentence reference 1 of 2025. And to the learned counsel for the appellant. You can pass a common order. You can pass a common order, but keep copies of both orders in both the books. Next one. You want a fixed date for hearing?
I think better, my lord.
Suggest a date.
My lord, probably after Eid, my lord, somewhere around in the month of first week of April.
First week of April would be.
Oh,
inconvenient because of
1st
the
April, my lord.
vacation.
Ah.
Take a date after.
Take it, no issue, man. Any date, say 2021.
Next.
21 is the hearing date, Tuesday, my lord.
Accordingly. List the matter for hearing on
1, my lord.
4/2026.
Much obliged, my lord.
Oh.
আপনি আমালে অর্ডার শিখতো পুরা অনলাইন নবা মানে কি হয় এই দ্বিতীয় কি এই কি পার্ট বহুত এটা ভাই হারাই যায় এটা বলছে স্টেট অফ তাই এখন বলো গিয়া
Presentation of what we have experienced law, teacher. Habeas corpus petition. Actually, I'm in the midst of a hearing in court number 5, my lord.
We'll keep it pending.
Till we-
We'll rise at 3:30. Before that, if you can come, we'll take it up.
Yes.
If you can't, then we'll adjourn it.
Fine.
When do you want? If it is.
Adjournment, I don't want because
No.
they have to submit a report, your lordship.
Okay.
Status report.
Oh, this is that child.
Yes, my lord. Can it be taken up, surely?
No?
If
Just a moment, Mr. Lordship. It is some urgency.
Lordship, order dated 22/1/2026. Thank you, dear Mr.
এটা এক্সট্রা এইটো করে দিব এইটো
Duka police station.
এটা পুলিশ স্টেশন আমি একটু প্রথম বাজাতো প্রথম বাজাতো চলে যায় এক্সট্রা দিকে মতন জিনিস দিকে তো দিন তোমার
My lord,
You've seen this.
just now I have got a copy.
The police has done what could be done.
They have another hang LGBI airport, so in so many places now.
Just a moment.
বহুত জায়গায় ঠিক হয়েছে ওয়ান আর সেন্ট্রালও তো পাঠাই দিয়েছিল বুঝছে এইটো দিয়া নাই থাকিব না এইটো চেন্ট্ৰেলতো তো পাঠাই যায় এইটো চেষ্টা করবি না এনে চাব আৰু
My lord,
Even to examine the case of Putuswamy,
lordship,
Justice Putuswamy's case,
my lord.
and then tell us whether we can pass orders putting the phones of the other family members into surveillance. Can we give the direction to the police? But you'll have to examine the case of Justice Putuswamy and then
My
tell
lord.
us, because we otherwise we have a feeling we don't have that power.
My lord,
But under these circumstances, when there's a habeas corpus, can we do it?
lordship.
Was the state, police officer, Justice Putuswamy said, without justifiable reason, the state cannot put the phones into surveillance.
My lord,
Under these circumstances, whether we can do it, this is often you have to answer us.
lordship. I have got alternative prayer, lordship, since the Assam police, on the last occasion, also I made the prayer, lordship. Because welfare of the child is at stake, or
But
this
if-
one,
If he has vanished,
my lord,
if the child.
এক্সট্রা আছে ওই জন্য Next sir, kada nahi? Next sir, yeah.
Lordship, this session would be, he's not attending school from last September, my lord. And this present session will be over, new session will start from March, my lord. So my father is worried, my client is worried, your lordship.
No, you see, we understand that anxiety. That is why we have taken up this
My lord,
matter.
Lordship,
Now, the problem is that if we have no idea where the child or the mother is,
yes.
please tell us how would you implement our orders?
Lordship, may I pray, if your lordship, directs, I may file appropriate application so that and it may be handed over to, CBI, your lordship, because Assam police is unable to trace out, your
No.
lordship.
For that, we'll have to record a finding that the integrity of that. If with all this, what they have done, we cannot arrive at a conclusion that
Conclusion.
it's a case warranting CBI any court of
Inquiry.
this. That's one.
My lord,
The second is that with whatever facilities they have, unless there is a specific order to put any place into surveillance, then they can't do it. Correct?
my lord.
When it's when anything which amounts to a criminal proceeding, then you know that the state cannot put into surveillance and do it. So the only way is that in connection with that matrimonial case, where the orders have been passed for giving the custody
Yes,
or visitation right, we can at best say that the said court will use its power to, after knowing from you the judge's, Swami's view of the Supreme Court, and say that they can put the issue directions for surveillance. Second is in the habeas corpus also we fully have the authority to to direct the state to make surveillance. Otherwise, we can't do it. It's purely a criminal jurisdiction, we can't do it, and you know that. So under these circumstances, in order to empower the state to do the surveillance, they have to tell us.
lordship. Monday, can it be on Monday, your lordship, coming Monday? Okay.
National one.
But this is something we are not putting it in the order.
My lord,
Correct? We are just adjourning.
my. 23rd. What are you doing? Happy birthday.
Now, are you aware of any passport of the respondent? Do you
Passport.
have information about passport, if any, of the
No,
respondent?
no, but lordship, in the morning, I talked with my client. He said she has got another phone number which she has intimated to the DCP. And it was found to be active at times. And she was also like online in the social media at times.
Those things we'll have to bring on record so that we can give it to the.
Phone number
Yes.
mention here.
Which phone number you have to tell us?
Yes.
You have to bring it
So
to
on
record.
Monday, I will just should make the
phone
submission.
number,
No, we have seen 3 phone numbers you have given.
Yes.
no mobile number had been active.
No, we understand, but you see this. If you have another phone number, you have to give us those numbers. Passport, according to you, she doesn't have.
I have no information.
No, because once the Bureau of Investigation have given the lookout notice, this has to be attached to the passport number. Then
Passport, my lord? Yes.
then whenever there is a entry in the airport with a passport,
Yes, authorities may impound the passport also. Lordship.
No, impounding is different.
Yes,
But this lookout notice becomes effective because nowadays we have this Digi Yatra and all the.
yes, my lord.
Those they bring to a passport
Yes,
can easily detect
Yes.
person entering the
yes,
airport.
yes, my. Yeah, I'm a people, baby. Passport.
Until happening was it in the series of us.
Let's not.
Mr. Sharma,
Lordships.
you have to request your the Home and the Police Department
Lordship.
to sensitize your police officers and IOs
Lordship.
to upgrade their digital skill by reading this VNSS.
Lordship.
You know what they have done? Suddenly we found interest in this report of 9/2/2026 by the IO.
Lordship.
You have given us this sheet, long sheet.
Yes, sir.
Let's get paper.
Hadigam PS.
Hatigao PS.
Yes, sir.
See the reference, Hatigao PS case number 3 of 2026 under 329(4).
Lordship.
Now 329(4) is house trespass.
Lordship.
We don't know whether she had done any house trespass. Now 296. 296 is obscene acts and songs.
Lordship, because video footage has come up, we have produced it in the other court, Lordship.
Obscene songs.
Yes, obscene songs and derogatory remark against the judiciary. And a lawyer also, along with this one, other side, Lordship, respondent, she had entered into the residence of the present petitioner while he was in bereavement, Lordship, while picking up the son, your Lordship.
Then you don't take the trouble of what you call finding out from Justice Puttaswamy. Because if Hatigao police station case is registered with those allegations of 302, 296 and all, then obviously we can't put the phones into surveillance. That will be collection of evidence, which is impermissible by virtue of the Justice Puttaswamy. Had it been only a case of missing child, then we understand we could have done. But to find out child is a issue of paramount importance.
Lordship, then thereafter the subsequent process, Lordship,
Then
subsequent development, my lord. From that day, the child got, Lordship, he is missing.
but this letter says, however, father of that second last paragraph, Mr. Sharma.
Lordship.
However, on 22/9, the father of the child so-and-so, believed due to demise of his mother during time so-and-so, along with a criminal trespass into the house, forcibly took away the minor child with her. Since then, the child has been found missing.
Lordship.
Now, if that is the case, why you add the criminal trespass? Even without the, only a kidnapping case would have been, the house trespass and the kidnapping.
Yes, Lord.
But why all this and complicate things?
And it is a statement made before by the learned public prosecutor before another court, your lordship, before the other court, that the whereabouts of the person, this petitioner, the respondent and her son is not known.
Yes.
What is the age of the child?
11 years.
Now, if I can discuss, then I'm very.
Lordship, because lordship, it's a part of the mutual agreement which they have arrived with, out of mutual consent, your lordship, that during the weekends and during the holidays, the father would have right to take the child back to his lordship, to his own residence, your lordship, and return back. On the last, on various occasions, on the earlier occasions, also, this honorable lordship has also granted order in favor of my client, your lordship, so that lordship, he can be taken back. Yes, your lordship. There was a order for custody of minor son in favor of me that was granted by the division bench of this honorable court. It was in operation. In violation of that, your lordship, she was taken away. Lordship, I'll.
Alex, page 74.
Lordship.
74. Okay. 74.
We have filed. And along with that is a IA, wherein we have lordship orders were in my favor, my lord.
DB NXR L. Alex.
Lordship, page 87 onwards.
It is named.
Lordship. Lordship, para 9, page 92. Today, when the matter is called, the respondent so-and-so is personally present before this court, keeping in mind that welfare of the child being paramount and keeping in view the denial visitation rights. This court finds it just and proper to direct immediate remedial measures. Accordingly, it is hereby directed as follows. The respondent mother shall hand over custody of the minor child. Page 92, has your lordship got it?
Yes, yes.
Namely Jasassi Vaibhavam Sonowal, aged about 11 years, to the petitioner, father, at a residence of the petitioner, that is so-and-so, before 5 p.m. on 22/8/2025, failing which the petitioner shall be entitled to take assistance of the jurisdictional police for securing custody in terms of disorder. Upon a respondent mother handing over the custody of minor child, as directed herein above, the petitioner father shall return custody of the minor son, namely so-and-so, aged about 11 years, to the respondent mother at a residence, that is on house on so-and-so. The officers of the charge of jurisdiction police station directed to render all necessary assistance to parties securing custody. Respondent in further warned that any future non-compliance with the orders of this court shall expose her to stern penal action. Then thereafter, another order was passed, your lordship. (26)8, your lordship, order dated 26/8. It's from page 96 onwards. Lordship, page 102, it is made clear that until further orders, the custody of the child shall remain with the petitioner. Page 102, para 10. Then page 105, another order which is in my favor, your lordship. Order dated 28/8. Then she was taken into custody, your lordship, at page 113C, order dated 16/9. 113C, your lordship. As the respondent is to be released from judicial custody on 23/24/9, so and so leaves the matter on 25/9. But prior to that, your lordship, the instant event has taken place. Lordship, at page 113G. Lordship, it's a part of the order dated 25/9/2025. As the orders dated 26/8 and 28/8/2020 are valid orders, which have not been vacated, modified, or set aside till date, the said orders have to be complied with to the extent that the custody of the child would have to remain with the petitioner husband till further orders are issued by this court. The petitioner may also ensure that the orders are complied with the help of the police. Then thereafter, Honorable Court, Lordship, registered, directed the registry to register suo motu case against the lawyer, Your Lordship.
You have done the paper publication?
Yes. Lordship, yesterday, client has sent, it was done in this one, Times of India, lookout notice. But regarding the other, because I didn't get so much of assistance from the investigating authorities, Your Lordship. Only after thorough insistence from my part, lookout notice was issued in this one, Times of India, Your Lordship. আপোনাক কিবা আহিছে নেকি এইটো?
কিবা লিখিছে কিন্তু
Lookout notice ৰ কথা।
Okay. So you have order, the custody order.
Yes.
Okay. Please. Be well and senior counsel assisted by Ms. Counsel for the petitioner.
Good, because of telegram or something in times and daily. Yes. The problem was also, they have already published in newspaper, Times of Telegraph, Assamia Pratidin, Times of India, electronic media, in police report. There are three. All things are published in Telegraph, News, Assamia Pratidin.
Date of this, date to now.
Times of India and Pratidin.
Telegraph, Assamia Pratidin, Times of India, and also in electronic media through Chief Public Relation Officer, Kamrup.
No, for your documents annexed, you have not given that telegraph.
Telegraph.
And there's no date, minor, on which.
No, it is there. The third page is there. Times of India is 16th February.
16th February.
Only date.
Samya
Yes,
Prasadin-
yesterday, Your Lordship.
Hmm?
Today's, we are 17.
16th on Times of India and 15th on in Samya Pratidin. As well as Mr. P. Sharma, other for the state respondent numbers 22. File. Next para is per office note.
May I pray the live proceeding be
Did it-
stalled, Your Lordship? Live proceeding be stalled?
No, the-
Lordship. Since your lordship was given 1 week time to take steps, after a week then. Yes, my lord.
Yes.
Lordship. Ultimately. My lord. Lordship. My lord, my respectful submission is that since she's not available, we have taken all the endeavor. Yes, my lord. Yes, she used to reside in the rented accommodation of her uncle. My lord. My lord. My lord, lordship. Two my lord. My lord. Obliged. My lord. My lord, lordship. My lord. Obliged. Lordship, may I get a copy of the status report if your lordship permits?
Item 33.
My lord. Lordship. No, he doesn't. Lordship. And I am praying for lordship not to, lordship should, live proceeding should be stalled because. My lord, no, sure, he will not hear. Sorry.
Yeah, go ahead. Lordship, may kindly permit me to show the illegality done during the inspection, your lordship. I'll just read out the provisions. How they have violated the provisions, your lordship. Lordship. Lordship.
My lord, in this matter, the petitioner has prayed primarily for setting aside an inspection report and the provisional assessment conducted pursuant to such an inspection report. Now, under the regime laid down under Electricity Act, your lordship, and the law laid down by the Apex Code, when a person indulges in theft of electricity, such theft of electricity will also be considered unauthorized use of electricity, and regardless of whether he is finally convicted or acquitted in the proceedings before the special court, the electricity charges payable by such person will be assessed under section 126 of the Electricity Act, and the Honorable Apex Court has held, since it is being assessed under 126 of the Act, your lordship, he has a right to appeal under section 127, even in cases of theft of electricity. The arguments raised before your lordship today that there is no appeal under section 154 or that the matter should be decided by the special court, that has been advanced and rejected by this honorable court by a coordinate bench and upheld by a single bench and upheld by a division bench, your lordship. So I'm carrying those judgments. If I may take your lordship to the provisions of section 126 first of the Electricity Act. So 126 of the electricity. Yes. Electricity charging. Yes. So in essence, what it means that every act of theft of electricity will also amount to an act of unauthorized use of electricity. But every act of unauthorized use of electricity may not be theft because there a dishonest intention is required. So that is the premise on which the Apex Court had proceeded. So if I may read section 126, Your Lordship. If on an Yes, if I may read section 126, Your Lordship. If on an inspection of any place or premises, or after inspection of the equipments, gadgets, machines, devices found connected or used, or after inspection of records maintained by any person, the assessing officer comes to the conclusion that such person is indulging in unauthorized use of electricity, he shall provisionally assess to the best of his judgment the electricity charges payable by such person or by any other person benefited by such use. And for the purposes of this section, what amounts to unauthorized use of electricity, Your Lordship will find in explanation B at the end of the section. Unauthorized use of electricity means use of electricity. We are concerned with number 3 here, explanation B. Explanation B to section 126, which defines through a tampered meter. So when a person uses electricity through a tampered meter, like in this case, that shall amount to an unauthorized use of electricity. And if he does that, then the electricity charges will be assessed as per the procedure laid down under section 126. And against that, he has a remedy under section 127. If I may take your lordship to section 127. Any person aggrieved by a final order made under section 126 may within 30 days of such order prefer an appeal in such form, verified in such manner, and be accompanied by such fee as may be specified by the State Commission to an appellate authority as may be prescribed. So, if I may take your lordship to 135 to just show the difference between these two provisions. They are in different parts of the Act. 135 also is concerned with tampering of a meter, but if your lordship has a look at the definition, it reads as theft of electricity. The sine qua non is, your lordship, dishonest intention. Whoever dishonestly we are concerned with B, tampers a meter, installs or uses a tampered meter, current reversing transformer, loop connection, or any other device or method which interferes with accurate or proper registration, calibration, or metering of electric current, or otherwise results in a manner whereby electricity is stolen or wasted. So as to, I'm reading from the end of the provision, so as to abstract or consume or use electricity shall be punishable with imprisonment for a term which may extend to 3 years, or with fine, or with both. So the only difference between tampering of electricity under 126 and 135 is the additional requirement of dishonest intention under section 135. So on this aspect, your lordship, this ground was urged in a proceeding, your lordship, which went up to the division bench. If I may take your lordship to the evidence of both the single judge and the division bench in those proceedings, your lordship. These issues were raised and answered. Yes, yes. My learned friend is aware of the judgment.
Got it.
This is 2021 4 GLR 558, Chevrolet Steel versus APDCL. There, your lordship, the issue was that similar to this matter, the petitioner had also indulged in theft of electricity in similar circumstances. And there, a provisional assessment and a final assessment was made under 126. There, they urged that they should not go. They urged that the writ petition was maintainable because they urged that the writ petition is maintainable because if a person indulges in theft of electricity, then only the special court is competent to finally assess the civil liability. So the issues which were framed in these facts, your lordship will find at paragraph number 7 of the judgment of the single judge. Paragraph number 7. Now the issues before the court are the first issue, whether the provisional assessment by the assessing officer against the act of indulging in unauthorized use of electricity after an inspection of any place or premises of a consumer and the final order of assessment of electricity charges payable by such consumer under section 126(3) is restricted only to such unauthorized use of electricity where there is no allegation of theft of electricity defined under section 135. B, whether section 127 of the Act of 2003 covers under its sweep the final order of assessment on the basis of provisional bill under section 126 of the Act of 2003 against the unauthorized use of electricity on the allegation of theft of electricity falling under section 135. And see whether considering the factual matrix, this writ petition is maintainable. The answer to the first issue your lordship will find at paragraph number 22. I'll not trouble your lordship with the entire thing here. After discussing the judgment laid down by the Honorable Apex Court in Orion Metals, the Honorable Single Judge, your lordship, was the opinion at paragraph number 22, issue A has been answered. In view of the said discussion, I am of the considered opinion that the provisional assessment by the assessing officer against the act of indulging in unauthorized use of electricity after inspection of any place or premise of a consumer and the final order of assessment of electricity charges payable by such consumer under section 126 is not restricted only to unauthorized use of electricity simpliciter, but includes such unauthorized use of electricity where there is an allegation of theft of electricity defined under section 135 of the Act of 2003. And accordingly, issue number A, that is whether provisional assessment by the assessing officer against the act of indulging in unauthorized use of electricity after inspection of any place or premises of a consumer and the final order of assessment of the electricity charges payable by such consumer under section 126 is restricted to only such unauthorized use of electricity where there is no allegation of theft of electricity defined under section 135 of the Act of 2003 is decided in the negative. Now, issue B, your lordship, regarding the appellate provision. That the response, the finding of the Honorable Court is at paragraph number 24 at page 577. I am unable to accept the submission of so-and-so inasmuch as the Honorable Apex Court in West Bengal State Electricity Distribution Company Limited, referred herein above, has held that as the special court is empowered to determine civil liability under section 154(5) of the Act in cases where a complaint is lodged, it could not be said that there is no power conferred on an authority to make provisional assessments or final assessment under section 126 of the Act of 2003. In the finding that the power conferred on authorities for making assessment under section 126 of the Act and the power to determine civil liability under section 154(5) of the Act cannot be held to be parallel to each other. Accordingly, if the authorized officer is authorized to pass a final order on the basis of the provisional assessment for unauthorized use of electricity, which covers theft by tampering of meter, section 127 covers under its sweep the appellate authority for any final order of assessment, including the unauthorized use of electricity with allegations of theft of electricity. Accordingly, the issue is decided against the petitioner. And the third issue, whether in considering the factual matrix, this writ petition is maintainable. The finding of the court on this issue, your lordship will find at paragraph number 26, starts at page number 578. May I read your lordship? In the present case in hand, the petitioner challenged a final order passed under subsection 3 of section 126 of the Act of 2003, along with the other consequential reliefs. The issue decided herein above shows that if final order passed under subsection 3 of section 126 of the Act also includes one against unauthorized use of electricity, where there is an allegation of theft of electricity under section 135 of the Act. Subsection 1 of section 126 of the Act of 2003 authorizes the assessing officer initially to raise the provisional assessment to the best of his judgment, the electricity charges payable by the consumer after the inspection. Subsection 3 of section 126 of the Act of 2003 allows the affected consumer to be heard, and thereafter the assessing officer is required to pass a final order of assessment. In the present writ petition, as herein above taken note, the petitioner disputed the provisional assessment and the final assessment order on the ground that there were no cogent reasons or grounds to impute the petitioner for unauthorized use of electricity with dishonest intention. Accordingly, the issues raised in this petition are factual in nature, coupled with the technicality of the metering system in the premises of the meter. Section 127 of the Act of 2003 allows any person aggrieved by the final order made under section 126 of the Act to prefer an appeal before the appellate authority prescribed under the said section. From the submission of the learned counsel of the petitioner and on perusal of the averments made in the writ petition, I do not find any averment showing that there was jurisdictional error while passing the final order against the provisional assessment made by the assessing officer. If there is any apparent jurisdictional error, there is no point in sending the matter to the appellate forum, inasmuch as that would be a mere wastage of time. In view of the said discussion, in my considered opinion, in the present factual matrix, which requires technical expertise for a decision, in the issues raised in the writ petition, the petitioner is required to file an appeal under section 127 of the Act against the final order dated so and so passed by the assessing officer. In the present writ petition, which is before your lordship, in the present proceedings, they tried to raise a jurisdictional issue saying that the inspection report and the materials contained in it does not confer jurisdiction on the assessing officer, or the materials are not enough to confer jurisdiction on the assessing officer to conduct a proceeding under section 126. That issue, your lordship, was decided by the learned single judge. If I may take your lordship to the finding of the learned single judge on this issue. That is at page number 248 of the writ appeal of the paper book. Lordship, this judgment which I had placed before your lordship just now in chief alloys, that was upheld by the division bench as well. I have just furnished a copy of the order passed in the writ appeal as well. So, if I may take your lordships to paragraph number 31, there a issue was sought to be urged before the learned single judge to the effect that the materials in the inspection report were not sufficient for him to conduct an assessment proceeding under section 126. On this issue, the learned single judge, your lordship, held as follows. It starts at paragraph number 31 onwards. After discussing the law laid down in Shiv alloys, page 248. 8. This is the impugned order. Paragraph number 31. Now coming to the jurisdictional issue urged on behalf of the petitioner, the case of the petitioner is an absence of prima facie case, an absence of any material having mens rea in the inspection report. The assumption of jurisdiction under section 126 of the Act of 2003 is invalid, and that once the theft is alleged, proceeding under section 135 of the Act of 2003 shall lie, and not proceeding under section 126 of the Act of 2003. The second part has already been answered in the foregoing paragraphs. The law is now well settled that a jurisdictional fact is a fact which must exist before a statutory authority can assume jurisdiction. If such a fact does exist, the authority acts without jurisdiction. Does not exist, the authority acts without jurisdiction. Existence of jurisdictional fact is open to judicial review, where the correctness or sufficiency of fact once jurisdiction is assumed is a matter of statutory authority and forums. In the case in hand, a review of the inspection report reveals that the physical inspection was conducted and prima facie evidence suggesting dishonest abstraction was collected. Applied in the present case and for the reasons recorded here and above, the jurisdictional fact for proceeding with and assuming jurisdiction under Section 126 of the Act of 2003 is already present in the inspection report. Since such material exists on record, however contestable, the jurisdiction is validly assumed. Thus, the argument on the merit of the inspection report and the evidence collected may be a subject matter of determination either before the assessing authority under Section 126 of the Act or before the appellate authority under Section 127. More particularly for the reason as recorded here and above that jurisdictional facts are present in the case, clothing the assessing officer stroke appellate authority with jurisdiction. Therefore, in the totality of the matter, this court is of the unhesitant opinion that the petitioner is having an efficacious alternative remedy under Section 127 so far as the same relates to the impugned assessment order, more particularly where the ARC has notified the court and in terms of the electricity removal of difficulty 2005 and adopting the procedure under Section 126 of the Act 2003. So far, the same relates to assessment of charges pending determination by the special court, exercising its power under Section 154 of the Act. Accordingly, in the opinion of this court, the present petition merits dismissal, reserving liberty to the petitioner to pursue the statutory alternative appellate remedy. While parting in the record, it is made clear that determination made herein shall not influence the authorities on the merit of the inspection report and the assessment made thereof. So what is sought to be urged before a lordship? My humble submission is the issue is no longer recentric, right? It has already been decided by a coordinate bench that even in cases of theft of electricity, the assessment of charges will be under Section 126, pending final adjudication by the civil court. And if the assessment is under 126, he automatically has a remedy under 127. And because of the technical nature of the subject matter, so the appropriate remedy would be statutory remedy constituted under Section 127 of the Act. So perhaps the petitioner, even in this case, your lordship, to be directed to avail that remedy. That is my submission.
Lordship. My case is that the assessment under Section 126 is totally different to that of the assessment to be made for restoration of electric supply. Our case is that the disconnection was illegal, your lordship, and the provisions for restoration of electric supply is given in third proviso to Section 135(1)(a). And the assessment to be made under Section 135(1)(a) is just an interim measure, your lordship. It doesn't determine the civil liability, your lordship, neither under 126 nor as done by the special code, your lordship. Lordship, we were agreed by the yes, your lord. The disconnection is illegal and the method for restoration of the electric supply is given under Section 135(1)(a), the third proviso. Under Section 135(1)(a), your lordship, the authorities are empowered to disconnect electricity supply, your lordship. And this is a drastic measure which can be adopted by the respondent authority. It is provided only under Section 135(1)(a) and nowhere else. They can disconnect only if there is theft, your lordship. Otherwise, they cannot disconnect. So the ingredients of Section 135 has to be prima facie attracted to disconnect the electricity supply. This is my case, your lordship. Now, after that, this is the primary line of argument, your lordship. The secondary is that once if the electricity is disconnected, then what is the provision for restoration of electric supply? The provisions is given in the third proviso to Section 135(1)(a). If your lordship may kindly come to third proviso of Section 135(1)(a), which is at page 15. Lordship.
We have a query here.
Lordship.
You see, Mr. Patil started his argument by saying that the theft of electricity is also unauthorized use of electricity.
Supreme Court judgment.
And then if it is unauthorized use of electricity, then a bill for the unauthorized use of electricity can be raised. I'm just asking you, if a bill is raised and there's a non-payment, why would someone go to 135(1)(a) and resort to it?
No, okay. I'll put it.
The electricity code for disconnection of electricity under the electricity code is available. What is that provision? 3.5 something?
Yes. Otherwise, to answer your lordship's query, this disconnection under 135 is automatic. So once he is found to be indulging in theft of electricity, not unauthorized use of electricity, theft, then disconnection is automatic. This assessment comes in only for the purpose of restoration.
So what
If
I'm
you-
saying is that the assessment for restoration
Yes,
is
sir,
quite
right.
different than the assessment under 126. These two are different. That I can substantiate.
1A of the provision reads, without prejudice to the provisions of this act, your lordship. So it's a non-obstant clause. It starts with a non-obstant clause, 1A. I'm reading section 135, 1A. Without prejudice to the provisions of this act, so this overrides everything else in the act, your lordship. The licensee or the supplier, as the case may be, may, upon detection of such theft or electricity, immediately disconnect the supply of electricity. Provided if I may read the third proviso to this 1A, your lordship. The third proviso reads, provided also that the licensee or the supplier, as the case may be, on deposit or payment of the assessed amount of electricity charges, in accordance with the provisions of the Act. Lordship will kindly take a note. In accordance with the provisions of the Act, shall without prejudice to the obligation to lodge the complaint, as referred to in the second proviso to this clause, restore the supply line of electricity within 48 hours of such deposit or payment. So the disconnection is mandatory, your lordship. As soon as it is detected, we may disconnect. But the restoration shall be on payment of the assessment charges, which are assessed in accordance with the provision of the Act. What the apex court and the coordinate bench held, your lordship, since there is no separate procedure laid down, the procedure under 126 will come in for calculating the assessment charges.
Supreme Court, you have not shown us.
Yes, I am carrying the judgment. If your lordship, very well.
Complete your part, goes.
I'll just finish the part. Detail.
Let him complete his part.
Yes, I'll just quickly show the Supreme Court judgment is there. The facts before the Honorable Apex Court was similar because the person had indulged in theft of electricity, and against the provisional assessment, like in this case, it had gone before the writ court, and ultimately the matter ended up before the Honorable Apex Court. The factual matrix your lordship will find at paragraph number 2.5 at page number 591. Yes. 2020-18 SEC 588. The factual background your lordship will find the relevant portion at paragraph 2.5 at page 591. Aggrieved by the provisional assessment and the consequential demand, the respondents have filed a writ petition WPC number so and so before the High Court, questioning the jurisdiction of the assessing officer in issuing the provisional assessment and the consequential demand for a sum of rupees so and so. In the writ petition, one of the grounds was that the assessing officer who had prepared the provisional assessment, not being a party to the inspection team, he had no authority to make the provisional assessment under section 126(1) of the Act. In the writ petition, it was also alleged that the provisional assessment made was not in accordance with section 126(1) of the Act, as such assessment cannot be given effect to. Now, the finding of the Honorable Apex Court, your lordship will find, it starts at paragraph number 598. Paragraph number 13, page number 598. It is clear from a reading of section 126(6)(b)(3), this is the explanation which I had taken your lordship through of the Act, that instances of use of energy through a tampered meter is included in the definition of unauthorized use of electricity. If that is so, there is no reason for excluding the power of the authorities for making assessment under section 126(1) of the Act to assess the loss of energy where electricity is used through a tampered meter. All instances of unauthorized use of electricity may not amount to theft of electricity within the meaning of section 135 of the Act. But at the same time, the theft of electricity which is covered by section 135 of the Act will fall within the definition of unauthorized use of electricity. As per section 135 1A of the Act, without prejudice to the other provisions of the Act, the licensee or the supplier, as the case may be, upon detection of theft of electricity, is empowered to disconnect the power supply immediately. Further, as per the third proviso to section 135 1A of the Act, the licensee or the supplier, as the case may be, on deposit or payment of assessed amount of electricity charges, without prejudice to the obligation to lodge a complaint, can restore the power supply of electricity within 48 hours of deposit stroke payment of such amount. Thus, it is clear that the authorities under the Act are empowered to make a provisional assessment and final assessment by invoking power under section 126(1) of the Act, even in cases where electricity is unauthorizedly used by way of theft. When a consumer deposits the assessed amount, the licensee or the supplier has to restore the power supply. The assessed amount referred to in the aforesaid proviso relates to assessment which is contemplated under section 126(1) of the Act only. There is an apparent distinction between the section 126 and section 135 of the Act. Section 126 forms part of the scheme which authorizes electricity supply to ascertain loss in terms of revenue caused to it by the consumer by his act of unauthorized use of electricity, whereas section 135 deals with the offense of theft if he is found to have indulged himself in the acts mentioned in clauses A to E of subsection 1 of section 135 of the Act. Further, it is also clear from section 154 of the Act, which prescribes procedure and power of the special court, that the special court is empowered to convict the consumer and impose a sentence of imprisonment. The special court, in cases where a criminal complaint is lodged, is also empowered to determine civil liability under section 154 of the Act. As per section 154(6) of the Act, in case civil liability is so determined by the special court is less than the amount deposited by the consumer or person, the excess amount so deposited by the consumer or the person shall be refunded by the licensee or the person concerned, as the case may be. Merely because the special court is empowered to determine civil liability under section 154 of the Act, in cases where a complaint is lodged, it cannot be said that there is no power conferred on authority to make provisional assessment stroke final assessment under section 126. So in essence, what it says,
Yes.
in essence, your lordship, what it says is that suppose today X is caught using theft of, is caught stealing electricity. And after conducting the inspection, the assessing officer is satisfied that that is theft of electricity. So he may lodge an FIR. Apart from lodging that FIR, he'll also institute proceedings for assessment under section 126. So that FIR, your lordship, what happens before the special court will depend upon the evidence and the outcome of the trial. It may or may not result in his acquittal. If it results in his acquittal, then the special court, then the assessment which has been made under section 126 will perhaps have to be refunded. But if he is convicted, then the special court also has the power of determining the civil liability, in which case any difference in the amount initially assessed, the consumer will have to make good. But the so once the inspection is done, your lordship, the assessing officer is clothed with the jurisdiction under section 126. The proceedings under section 135, they are parallel and they will proceed, your lordship, as per the procedure laid down in the part 14. So that has absolutely nothing to do with what is before your lordship in these proceedings. These are proceedings under section 126, where the petitioner has a remedy under section 127, and he has rightly been directed by the honorable single judge to avail that remedy, your lordship.
Yes.
Lordship, have already seen that under 126, assessment can be made, provision bill will be made. Then thereafter, we have a right to file a representation, objection, and thereafter the final bill will be made, and thereafter we can file an appeal under section 127. This is once how to assess the civil liability. This is one under 126. And your lordship have also seen the jurisdiction of the special court to assess the civil liability when there is theft, your lordship. Now, here the question is what will happen when the electricity is disconnected? How to restore? And as I have already shown your lordship, under the third proviso of 1A of section 135, there is this specific language is there, provided also that the licensee or supplier, as the case may be, on deposit or payment of the assessed amount of electricity charges. Now, what is this assessed amount? So there, this question arose, and accordingly, the electricity removal of difficulty order was passed, your lordship. That your lordship will find at page 25. This will clarify everything, your lordship.
25 of your compilation.
Yes, your lordship.
No.
I'm reading from the beginning, it's a single page, your lordship. Whereas the Electricity Act so and so came into force on 10 June 2003, and whereas section 50 of the Acts provide that the State Commission shall specify an electric supply code, which has been done in our case, to provide for recovery of electricity charges, intervals for billing of electricity charges, disconnection of supply of electricity for non-payment thereof, restoration of supply of electricity. Restoration is given, the assessment is not given, and so and so, so and so. And whereas the distribution licensee have expressed difficulties in controlling the theft of electricity and in taking appropriate action in this regard. And whereas enabling the distribution licensee for taking timely and appropriate action in case of theft or diversion of electricity has become necessary for the development of the electricity industry and ensuring supply of electricity to all means. And whereas taking measures conducive to development of electricity and supply of electricity to all areas are objectives amongst other of the Act as stated in the preamble. Now, these two paragraphs are important, and whereas the difficulties have arisen in giving effect to the provisions of Act in controlling theft of electricity by the distributing license. Now, therefore, the central government in exercise of power conferred by section 183 of the Act hereby makes the following order in respect of electricity supply code in terms of section 50 of the Act, not inconsistent with the provisions of the Act, to remove the difficulties, namely, so and so order number 2. Section 2, order 2, inclusions of measures to control theft in electricity supply code. Subsection 1, the electricity supply code as specified by the State Commission under section 50 of the Act shall also include the following, namely, method of assessment of electricity charges payable in case of theft of electricity pending adjudication by the appropriate court. So this order has been made only so that a particular assessment method can be prepared by the respondent authority for assessment pending adjudication by the appropriate court in matters of theft, your lordship. That is why I have been distinguishing this particular assessment for restoration of electricity supply. It has nothing to do with section 126 or the power given to the special court. This is an interim matter adjudicating the pending adjudication by the appropriate court, your lordship. On the basis of this, what they have done, they have amended the supply code and they have made a provision which is similar to 126. That I have not challenged, so I am not on that. But that assessment cannot be said to be an assessment under 126. Rather, it is an assessment pending adjudication under this order for the purpose of third proviso of 135(1)(a). This has been confused, your lordships. And both the judgment that my learned friend has shown, one division bench of this honorable court and the other one of honorable Supreme Court, both the judgments are sub silentio and par imperium because this order was not placed before those benches, your lordship. It went sub silentio, your lordship. And there is a very good judgment by your lordship that Ganesh Chandra Pathak, your lordship. 2018, your lordship will remember, your lordship, where sub silentio has been elaborately discussed, your lordship. And above all, there is a Supreme Court 3 judges bench judgment, which is Sitaram, that I am placing, your lordship, which has distinguished 135 and 126. That also I am placing, your lordship is aware about the judgment, then also I am placing, your lordship. So my contention is very simple. Under this removal, why is this removal of difficulties order required, your lordship? The only purpose is that under third proviso of 135(1), a particular assessment can be made. It's a different thing they have adopted 126, but that cannot automatically transform into section 126. And in both the cases that my learned friend has shown, the facts of the case is that the provisional bill were made in 126. But in my case, I have shown in the inspection report, it is 135, not 126. Neither it is 135 read with 126 as my learned friend is now trying to put up. Even if I admit for one moment that his argument is right, Your Lordship, 135 can be put as a subset of section 126. Then also in my case, in the facts and circumstances of the case, it is 135, not 126. But in both the Orient Metal judgment and C-Value judgment that my learned friend has put up, those cases were under 126 exclusively, not under 135. The bills were raised under 126. So those facts are different. And it is also substantial, Your Lordship, because this 2005 order removable defeat was not discussed in both the judgments, Your Lordship. Whereas in 3 judges' bench of Sitaram, it is specifically stated. I have already furnished Your Lordship, Sitaram judgment, Your Lordship, my kindly peruse. Paragraph 15B. मेरा वाला निकाल दो. Sitaram is a 3 judges bench judgment of the Honorable Supreme Court, Your Lordship. At paragraph 15, which is at page 119 of the judgment, Your Lordship, that I have furnished just now. Do copy as tomorrow. Duta diyo. Duta diyo. For restoration of electricity, if the power is given to them, the bill was raised at rupees 5 crore, and I have shown for a period of 3 days. Can the assessment be for rupees 5 crore in any industry, Your Lordship? The period I have shown only to show that in 3 days there cannot be an assessment of 5 crore. Even if I have stolen electricity, can I steal 5 crore worth electricity in just 3 days? Paragraph 15 at page 119, Your Lordship. B, this is the ratio of the case. Distinction between section 126 and 135, Your Lordship, got it. Paragraph 15, Your Lordship. This is the ratio of the case. Now, this is answered in paragraph 24 to 30 of the judgment, Your Lordship. At page 123, Your Lordship. Of the judgment. Your Lordship got it, paragraph 24. Heading is distinction between section 126 and 135 of the Act. 24. Upon the plain reading, the marked differences in the contents of the section 126 and 135 of the 2003 Act are obvious. They are distinct and different provisions which operate in different fields and have no common premise in law. We have already noticed that section 126 and 127 of the Act read together constitute a complete code in themselves, covering all relevant considerations for passing of an order of assessment in cases which do not fall under section 135. Now, next paragraph, Your Lordship. Section 135 of the Act falls under part 4 relating to offense and penalties. Your Lordship has already shown it. And title of the section is theft of electricity. The section opens with the words, whoever dishonestly, unquote, does any or all of the Act specified under clause A to E of subsection 1 of section 135 of the Act so as to abstract or consume or use electricity. This is important. So as to abstract or consume or use electricity. So under 135, number 1 is dishonest intention, and secondly, the Act should be in order to abstract or consume or use electricity. Then only it shall be punishable for imprisonment for a term which may extend to so and so and so and so. Besides imposition of punishment as specified under the provisions of the proviso thereto, subsection 1A of the section 135 of the Act provides that without prejudice to the provisions of the Act, the licensee or the supplier, as the case may be, through officer of rank authorized in this behalf by the appropriate commission may immediately disconnect the supply of electricity and even take other measures enumerated under subsection 2 to 4 of the said section. The fine which may be imposed under 135 is directly proportional to the number of conviction and is also dependent on the extent of load abstracted. That load has to be, if it's a theft, merely by saying theft, it will not suffice, your lordship. They will have to show in the inspection report what is the load. Otherwise, how the special court will punish me, even if I've stolen electricity? They have not done that. They have violated all the provisions of law while preparing the inspection report. Without the kilowatt, what I have stolen, how can 135 be there? They have resorted to 135 only so that they can disconnect my electricity. That cannot be permitted, your lordship. At best, my case can be under 138. There is punishment under 138 also. There is fine under 138 also. Civil judge can impose penalty. Civil judge can punish me, put me in imprisonment, your lordship, under 138. Why they have not resorted to 138? So that they can disconnect my electricity and force me to pay rupees 5 crore for any kind of irregularity in just a period of 3 days. This is not the intention of the statute, and that is why the removal of the difficulty order was passed, your lordship. We all support that there should not be theft. We all support that, your lordship. But there was some removal because the statute was silent regarding the assessment, your lordship, pending adjudication by the special judge. And that is why they have been directed to put up a formula under section 50 so that an amount can be assessed, your lordship. Not under 126, your lordship. That's a totally different provision. A complete code in itself, your lordship. Now, paragraph 26. In contradiction to these provisions, section 126 of the Act would be applicable to the cases where there is no theft of electricity, but the electricity is being consumed in violation of the terms and conditions of supply leading to malpractices, which may squarely fall within the expression unauthorized use of electricity. Now, at this point, if I may pause, your lordship, I support my learned friend's contention that for theft, there is a requirement of mens rea, that dishonest intention has to be there. And that is why 2 different sections, 2 different code, 2 different chapters. Theft is not unauthorized use of electricity, your lord. For unauthorized, I may not be dishonest, but for theft, I'll have to be dishonest, your lordship. That is the simple dictionary meaning, your lordship. The assessment proceedings would commence with the inspection of the premises by an assessing officer and recording of a finding that such consumer is indulging in an unauthorized use of electricity. Then the assessing officer shall provisionally assess to the best of his judgment. This is also important. This assessment has to be based of his judgment. Now, I will not bother your lordship because your lordship is aware. Based of the judgment, as it comes from the Income Tax Act, your lordship, similar, your lordship. The electricity charges payable by such consumer, as well as pass a provisional assessment order in terms of 126(2). So 126 is base judgment assessment, and 135(1)(a) third proviso is as per the removal of difficulty order 2005, your lordship. Entirely different, your lordship. No commonality, your lordship. And this is what the 3 judges bench of the Honorable Supreme Court has said. Then also the judgment that my learned friend had praised, the sieve alloy and the Orient metal, both did not discuss the 2005 order. It went sub silence, your lordship. And there are also others. I can show your lordship why it is par incurem also. That also I can show. And in both the judgment that has been given to your lordship, it is under 126 exclusively. Here it is 135.
No, 135.
Okay, but bills were raised under 126. Sorry, I correct myself. Bills were raised under 126 in both the cases. Here, bills was raised under 135. And sometimes they also have seen other bills where they put it under 135 and made it 126. Not in our case, your lord. Citizenship পরিষদ 2005 order point. Hedo subsidiary. Subsidiary. ये कहाँ से पढ़ रहा है? हाँ, पहला है तेरे का 24 जो पढ़ा है। क्या वापस पढ़ा?
अब एमडी का सर्कुलेट दिखा दे एक बार। अब पूरा एमडी का सर्कुलेट। Sixty of composition files before the research किया है। One last thing.
Now, the Orient Metal, I must fairly submit, he has just reminded me. In Orient Metal, this Sitaram case was discussed, Your Lordship. This Sitaram case was discussed in Orient Metal, but I'll say that I'll submit that Orient Metal is power increment because the paragraph 26 of the Sitaram was not taken into consideration here. This is three judges bench, Sitaram, and Orient Metal was passed by a division based on the Honorable Apex Court, Your Lordship. Even though this was considered, but paragraph 26 was not taken into account, so that will go up power increment, Your Lordship. And also,
Reasoning was taken into account.
reasoning was taken into account, but this particular sentence, which I have shown, Your Lordship, that section 126 of the act would be applicable to the cases where there is no third party electricity. This is as per the ratio. This is the ratio of the case of Sitaram, Your Lordship. I've shown in paragraph 15b that the ratio is distinction between 126 and 135. यहाँ से दिखाना, मैं अभी वहां से यहाँ कैसे मिलाते रहूंगा? हाँ, यही तो है, बोला ना, बार बार एक ही पड़ेगा, तेरे का कोई है ना? And in paragraph 24, if I may reiterate, Your Lordship. Yes, sorry, Your Lordship. I think I'll continue with you. इसका नहीं कोई बाहर से बोल रहा हूँ।
कहीं वोल्टेज को नहीं पढ़ाया so they assume these excess charges were more defined, so court assumed it is under 126. लिखा दे assume तो भी ये और एमडी का सर्कुलर दिखा दे तो चीज पैराग्राफ का ये नहीं रिलेटिव पे ये नहीं दिखा सकता
नहीं है
सुनिए वो लिखी मैं बोल रहे थे बदल इवन के लिए रखा है इसमें बताइए
Lordship, I'm just reiterating. Lordship. Tomorrow, Your Lordship.